Hello and welcome back to the Education Magazine. And today's programme is going to be answering your questions. And Chris, we've had many questions.
We have had a lot, Mike. That's true.
Yes, as you can see, I'm joined by Chris McFarland, who's going to be answering some of the questions today. And we have also the delightful Charlotte Hadfield, who you've met many times before. Charlotte, lovely to see you back.
Thank you, Mike. Lovely to see you too.
And Chris, it's been a busy year, hasn't it?
A very busy year, yes, and a long year ahead as well.
And are we prepared for all these questions, Charlotte?
I think we're ready.
That's what's going to dominate this programme. It's going to be the questions that you have asked. And I put it out on Facebook, didn't I? I said, any questions for us? You send them away. We had so many, I got to say. And in fact, we've done our best to try and condense as many as we can into this hour slot that we have for today. And if you haven't had all of the questions answered, that's probably going to be because we've answered them in previous programs. So there's going to be some links on screen that will be set up, which will direct you to other programs where we've dealt with these kind of issues before. So, for example, fabricated illness, those kind of things. We've dealt with that in previous programs. We have a whole program on fabricated illness. And we've dealt with some things about education otherwise in at school too. So anyway, because we've got so limited time, I'm going to go straight into the questions, Chris.
Exciting stuff.
So the first question is, does a school need a medical letter from a parent in order to mark the child as being authorised for being absent? Or can they do it without such a medical letter? Chris, what do you think of that?
Well, I think it's one of those pragmatic questions that we come across. And I remember that Charlotte was the one who really wanted to take this one. So I'm going to throw this one to you, Charlotte. We're going to pass it on. What do you think?
Charlotte, come on. You've got to answer this one.
So the answer is that a school, it is actually quite a pragmatic answer, but basically an absence is authorised if the school agrees with the reason that you have put forward for your child being absent. So the circumstances in which a school will authorise an absence are, firstly, that the child is too ill to attend and the school accepts that as valid. So my understanding is that schools generally should accept that an absence is due to illness unless they've got a genuine cause for concern about whether the illness is genuine or not. So, if you have a child who's present all the way through the academic year, keen as mustard when they're in school, and the parent calls and says, this child has a headache or my daughter's feeling sick or whatever it is, you would expect the school to authorise that absence. If the school does have concerns about either that an illness is authentic or perhaps they're just concerned that a child has had a loss of absences and they would like more information about it, then they can ask parents to provide medical evidence to support that. And that could be a letter from the parent or guardian. There are sometimes difficulties, I think, in terms of getting sick notes from GPs because not all GPs will write sick notes for children. And so generally speaking, I would expect if the school asks for evidence, which they won't necessarily always ask for, but if they ask for evidence, what they would be asking for is written confirmation from the parent or guardian that the child is ill. And the other circumstances in which absences could be authorised would be where you've got advance permission from the school to take your child out. So a religious festival, perhaps something like Yom Kippur or celebrations for Ramadan, those could be reasons why you might take a child out of school, and you would expect that the school would agree to that. Holidays are obviously a bit more of a vexed issue. You could probably do an hour-long talk just on the circumstances where you can take your child out of school for a holiday. But if the school agrees that you can take your child out for a holiday, then that absence will be authorised. Medical appointments, dental appointments, study leave, being educated off-site. So those are the circumstances where an absence can be authorised.
I was going to say a follow-up element to this question was about the use of private practitioners. Just to be clear, obviously, we don't know the context of that may be behind any particular question, but where you have a registered and qualified clinician, be they a doctor or possibly a therapist or psychotherapist, remember, they will be under the regulatory duty to be honest and truthful in their accounts. So it's very, very important that whether parents have had to commission a private expert, because as Charlotte has mentioned, GPs, and I really do find this quite strange, and it's a fairly common practice, though, that GPs don't write sick notes for children, even if it's pretty obvious. Whereas for parents, of course, for adults in the world of work, it's a very, very common thing to do. But of course, sometimes that does mean that parents have to look beyond their GP surgery to get a documented evidence. And there's also, no specific requirement that they be of a certain level of qualification. Quite bizarrely, I came across a case where a local authority was asking for a consultant letter. And I thought, well, under the NHS, the idea going to be before a consultant for tonsillitis is pretty rare. So it's very strange, these kind of requests. So it can be any medical practitioner or a qualified practitioner, provided they're qualified in that field. Obviously, a speech and language therapist is not going to be saying the child's too unfit.
But I suppose the question also is based upon what kind of quality evidence would be needed to verify the child being marked as authorised, or being authorised to be absent. And it would also depend, it seems to me, on the amount, the frequency of the absence. Yeah. The more likely, it would be more likely to be reasonable, wouldn't it, Chris, for a school to request some sort of verifying evidence if the child is frequently unwell.
Yeah, or if they've been unwell for a long time. So if you have a child who's been off for, it's very difficult to put a length of time on it, but certainly if your child's been off for sort of more than a week, certainly more than 2 weeks, I would think that you're into the realm, it's unlikely to be unreasonable for the school to want some evidence about that. And if the other thing is, if you're saying to the school, my child's being investigated for throat problems, or my child has had to go to hospital on a number of occasions. Again, that's the sort of situation where the school might say, well, we want to know a bit more about this.
Yeah, and I think as well, it's like anything. It's about being compassionate and being pragmatic from a school's perspective. They need to acknowledge, particularly, health systems are still struggling post-COVID, even now that we are thankfully out of a lot of the restrictions. And as we've talked about, a lot of GP surgeries won't provide letters or evidence, certainly in the early doors, about a child's needs. So, I think that there's no reason to put in place unnecessary barriers, but it's always good to have a dialogue. If a child is out of school and you're worried they may have missed too much, have them in for a meeting, talk about how you can help them catch up. And also remember that if it is an ongoing difficulty, that there are duties to make reasonable adjustments, which will come up in questions later as well. So having a meeting can also be like, well, is it something to do with school? Is the child exhibiting a school anxiety, for example? Are there ways that we as a school can put in place little strategies that if there is something that's keeping the child off regularly, it might mean that they're at least coming to school part-time or starting to go to school? I think with anything, it's very fact-specific, so just be compassionate and pragmatic and don't put in place unnecessary barriers. If you're going to say, we're not going to allow or authorise any absences without medical evidence, you're putting in place something very difficult. Just be pragmatic and sensible about it. And if you have concerns, enter those discussions.
And just to underline, it isn't reasonable for a school to say we're not accepting medical evidence from this practitioner because they are not an NHS practitioner. It's not going to be reasonable, partly because of what Chris said about the duties that they have from their regulator, but also the private practitioners don't work for the parents. Whoever is paying them, they are treating the child. The child is their patient. Their duties are to the child.
Absolutely right.
Well, thanks, Charlotte. Thanks, Chris. Let's go on to the second question. And this question says, now that schools are academies, and if they fail to meet special needs, if that is the academy, I think we probably more broadly should say schools rather than just merely academies, because I think the law is the same. Yeah. What do you do if the school fails to meet the special educational needs of the child? Who is accountable? Is the question. That's the question. So, who is accountable, Chris?
So it depends whether or not the child has an education healthcare plan, a statement or an IDP, if we're talking about England and Wales, and 3 statutory documents. So obviously in England, if it's an Eacp, the local authority still remains accountable. It doesn't matter if the child's at an academy, doesn't matter if the child's at an independent school that's named in the education healthcare plan. Duty always falls to the local authority in every circumstance. In the context of a child that hasn't yet got their statutory document, then schools do have best endeavours duties under the Children and Families Act to try to meet the needs wherever possible. They also have obligations under the Equality Act to make reasonable adjustments. Now, these duties do not go as far as those applicable to local authorities under the Children and Families Act. So best endeavours means obviously they've got to try and they've got to make their best efforts to secure provision. But of course, there are certain things, for example, a typical mainstream school or even a typical academy probably won't have access to therapists. So of course, it may not be possible for them to actually arrange therapists because it's beyond their budget or remit to do so. Likewise, the duty to make reasonable adjustments, there is that obligation to do so, both to put in things like an auxiliary aid or make physical changes to the school layout if a child, for example, is in a wheelchair and needs ramps to get around. But again, there are certain limits to that duty where the adjustment requested is beyond the realms of reasonableness. And that doesn't mean that it's an unreasonable request in the general sense. It means that when we look at the factual context of the case, is it too expensive? Are there no resources to provide that level of adjustment at that school level? So there are some duties, but they're very, very fact specific, and they all essentially go into the investigation of what the school has done. Have they exhausted their best endeavours? And secondly, is the adjustment being requested a reasonable one?
I mean, in this question, I think, Charlotte, what's being said is that the local authority in this particular case are said to be 3 months overdue. And the person who asked the question says, well, why can't the provision that they know about already, and it's going to take 6 or 7 weeks or maybe longer for the authority to complete the assessment, why can't they make the provision right now? I mean, it's a practical problem that we see frequently come up, don't we? I mean, a speech therapist advises on day one, let's say January, child needs speech therapy, and local authorities ask for a statutory assessment, say in March, and it takes months before the assessment is complete. What about in that intervening period? And I think you've answered that question quite well, Chris. I mean, Charlotte, have you got anything to add on that?
No, I thought Chris's response was pretty complete.
Lovely. Well, let's go.
One final thing I would add, where we talk about assessments being late, EHC assessments being late, it's important that 20-week period is to be adhered to, and so there's a twofold problem here. There's, as we talked about, can the school or academy in this context make the arrangements? And of course, do request them and remind them of those duties, because it's important to do so, and it's an obligation on them to explain why, for whatever reason, they can't do these things. But secondly, make sure the local authority is being held to account for its delays, because that's not helping matters. It is actually very helpful evidence. If you go to a school and say, school, I need this provision, they say, I'm really sorry, we can't do it. Well, that really strengthens your chance for an EHCP, because you're getting direct evidence that an EHCP is necessary, because your school or academy is saying, without EHCP funding, we cannot do this. So I would say do both. Chase up your local authority, get the EHC assessment done, and also make sure you're chasing up the school to give you reasons why they cannot do it in the interim.
Thank you, Chris. I'll go straight into the next question. Maybe this one for us all, maybe, but where therapy is named in section F of the plan, and of course the same applies to cases of IDPs in Wales. Let's say occupational therapy, speech therapy, and psychotherapy. The questioner asks, who should take the lead in the funding? So I suppose it's a case where you have this sort of hybrid provision which crosses domains of education and health, OT, speech therapy, that kind of support. Who takes the lead responsibility for the funding? Charlotte, what do you think?
Well, from a statutory point of view, it's not really relevant, because social care and education are both parts of the local authority, and health funding, it's something. Health funding is not really. It's not really. I suppose what I'm saying is, when you get in front of a tribunal, the tribunal really is not concerned with how the provision is going to be funded. The only question the tribunal asks is this special educational provision? So is it educational provision, or is it mixed social care or health and educational provision, in which case it goes in section F. Now, the local authority and the NHS or the CCG can come to any number of agreements between themselves as to how provision in section F is going to be funded, but that is not relevant to the question of whether it goes in section F. And so I guess my pragmatic answer is, from a parental point of view, this isn't really your problem, technically, except that in practice there are times when there is a delay or a resistance to naming therapy in section F, which is led not really by the question of whether the child needs that and whether it's educational in wholly or in part, but who in the local authority is going to fund it. So sometimes you can get caught up in a budgetary dispute, but as a matter of law, it's not your problem as the parent. Someone's got to fund it. Let those agencies duke us out between them.
It's coming up a lot these days, Chris.
Yeah.
I'm having it. We were talking about it yesterday, weren't we? About in a case of judicial review, which we've said local authorities not complied with the plan, hasn't delivered the speech therapy, and the response was, we're doing our best, but we can't find it.
Yeah, absolutely. And there is case law that's very clear that for the local authorities, very different to academies we just spoke about, it's not a best endeavours duty. You can't try your best and fail. For local authorities, it's secure. And what's important is, if therapy is named in Section F, so you've gone beyond the kind of circumstances Charlotte has talked about where do we put it in the plan? Well, okay, we've all agreed it's in Section F. It's now in Section F, and it's confirmed as a final plan. The buck stops with the local authority, and that's what Section 42 says. Where it's educational provision, it stops with them. And as Charlotte said, at that point, how the sausage is made is not your problem. The local authority can have service level agreements with the health authority. It can have different arrangements between its departments. It can do whatever it likes to a certain extent, but its obligation is to secure that provision. So if that provision is not being provided, it is not secure, local authority is in breach. They are who you take to judicial review. And they can't weasel out of it by saying, oh, we're doing our bit, but our service level agreement isn't working. The answer to the judge in that case is tough. It's your job. If your service level agreement's not working, do something else. But the buck stops with them.
Absolutely. Right. Well, next question. What can you do to ensure your child has the appropriate support in college? And the questioner says, bearing in mind that in Wales, the current year 11s and above leave school with what the questioner says is a non-statutory learning and skills plan. Well, I think we should clarify that point. It is a statutory plan. But they go on to say that new legislation covers up to the current year 10s, so that their statements will end. And the questioner says, I'm sure that some colleges will embrace and provide the right support, but others don't do so, and they're not proactive enough. And of course, this is a problem, particularly for those in Wales, I think, far more so than in England, because in England, the education healthcare plan regime extends into the further education sector, and in fact goes on up to 25 unless you go to university. But I'll come back to university later. There's another question. I'll ask the question on that. But in Wales, it's a bit more tricky, Chris, isn't it?
It is, and it's particularly because we're transitioning from an old system under the Education Act 1996 and the Learning and Skills Act 2000, which is where this plan actually does have a statutory backing. It's just not as strong as the statement, which is why you don't get that same level of strength. Why here it's been referred to as a non-statutory plan, even though technically it's under statute. It's just a different one. So the IDPs, so we're moving to IDPs. IDPs will extend to further educational college, and they can. So if your additional learning needs have arisen at college, they can be dealt with by the college currently. It's more about those that currently have statements. So they are still, and I have to say, I think this has been a big mistake by the Welsh Government to keep the old learning and skills plan as a key part of their first couple of years, because they haven't really said when those with statements are transitioning to the new system. Whereas in England, if you both recall, you were both practicing at the same time, as was I, when Children and Families Act came in, that was the first thing. They were the priority. The people moving to the Learning and Skills Plan were the first people to get EHCPs. They were the people targeted first. And I think with good reason, because if you're bringing in a new, better system, better for the people who would grandfather out of the old system of statements to get the new plan first. Whereas here, I can't fathom why.
No, I can't.
But they've decided to stick with the learning and skills plan, and it isn't as strong. They're not written as well. They're not as enforceable because it's a general enforceable duty rather than a more specific duty to enforce. So it is quite frustrating. I mean, the reality is what is within the learning and skills plan, should be provided at the college level. So obviously, support that's listed in there should be provided, and you can look to enforce that as well. There is also, as we talked about before, with academies and schools, there is still that Equality Act duty to make reasonable adjustments as well. So even if something isn't necessarily specified in the learning and skills plan, but is still a reasonable adjustment, be that maybe extra time to do work, maybe more flexible deadlines, other support that their child may require, you may be able to enforce it that way. But I can understand the frustration, disappointment on the part of parents in Wales that they're going to that weaker system that we hoped would be really the first to go.
I agree. I mean, Charlotte, it really is a problem, isn't it? Under the old regime of learning skills plans, which applied, of course, in England before the Children and Families Act.
Yeah.
I mean, a lot of parents in those circumstances, or young people in those circumstances, only then had a right, didn't they, of appeal to the funding agency's body, the internal process. Yeah. And the same applies now in Wales, that the appeal is to the Welsh Government. I just wonder, I'm going to throw this one out, can we say that it is unlawful and discriminatory for not helping or potentially not providing a fair right of appeal to an independent, impartial tribunal when the will of Parliament is that IDPs should extend to 25? And this is the very group that is actually needing it the most at the moment, because their provision is going to be under this old regime and not the new one. I just wonder.
Well, I think there's a twofold to answer that. So obviously the law isn't currently implemented for these individuals.
No, but there's a judicial review, as you know. This firm is dealing with over the Parliament having passed law that adult sites should have age verification, and an application has been brought for judicial review for the government, the executive, to put in place the will of Parliament, to ensure that they apply the will of Parliament. And in this instance, the Welsh Parliament's will is to extend the support up to the age of 25, and the very group that needs it the most have not had this support.
It's a very interesting proposition.
If you're out there and you want to take a challenge, Charlotte, I'm sure you'd be the barrister for it. What do you think, Charlotte?
It is a very interesting question. I'm keeping quiet because I haven't thought about it enough to have a sort of proper view of it.
It's a very nuanced point. I like it.
I like it in theory. I suppose it's one of those that, like any good question, needs to be tested.
Yeah, well, as I say, we would certainly want to hear from you if you're in that dilemma and you want to think about it. We will certainly look at that and give that some thought about whether that is something we would want to take. The next question is, what advice should be given to a parent with a child who is unable to attend school due to anxiety and has unmet special educational needs? And that child is receiving 12 hours of online classes in core subjects only, which covers English, maths, and science. And at Key Stage 3, they say, the policy says that local authorities should provide tuition in core subjects only, and children who are on the roll are supposed to provide tuition. They say, the questioner asks, should they not be provided tuition in all other subjects too? Charlotte, do you want to go on that one? What do you think about that?
Yeah, so I'm going to assume that everybody, including the relevant local authority, has agreed that this child is not fit to attend school, because generally speaking, if the local authority doesn't accept that, then the child wouldn't be receiving LA-funded tuition at home. So the statutory right, if you have a child who is unable to attend school because of illness or disability, is to full-time equivalent education otherwise than at school. So that could be in the form of home tuition. It could be in the form of the child attending some other facility that is not a school but has been deemed to be a place where they can receive education. But the right is to have full-time equivalent education, which we were talking about this earlier, weren't we, Chris? We think it's probably around 25 hours, but there isn't really a sort of cut and dried equivalent. But the important point is that doesn't mean your child effectively does a typical school week at home, like a sort of 8:45 to 3:30 p.m. week with lunches and breaks, because you have to take into account that your child is the only child in the class and therefore will be receiving more intensive provision. It's an interesting question. I mean, the statutory intent, I think, is that the child is supposed to have full access to education outside of school if they can't attend school. And so I metaphorically raise an eyebrow at the suggestion that the LA is only required to provide core provision. Now, the LA could provide a full education across the week for that child by agreeing with the school. If the child is on the roll, and sometimes a child who is receiving education otherwise will still be on the roll of the school, there's no reason why the LA and the school couldn't agree for non-core subjects, for example, to be provided by the school online or something along those lines. But it is the LA that's on the hook for providing the education, is the answer.
Yeah, absolutely. It's certainly a curious position. It's very fact-specific. We need to have a look at the exact circumstances of the case. And that's sometimes the problem with these types of general questions. They do require that more nuanced analysis, which can only come from formal instruction. But it's certainly questionable. I think the idea of limiting it only to core subjects is certainly something that we need to see justification for, and only 12 hours as well. I mean, as Charlotte said, the DfE guidance for those in England, and it's a similar application in Wales, where we say full-time, where it's one-to-one, it doesn't have to be the same number of hours, doesn't strictly have to be 25, because obviously you've got much more intensive instruction than you would in a class of 30 in a mainstream school. However, that does not mean 12 is adequate either. It really depends on the circumstance of the case, and also the child's needs. I have had a case previously where the child, and it was no one's fault, the child was very, very unwell. And that meant that they could only really learn for about 5 hours a week, because they had such profound difficulties. So in those circumstances, that child's full time was 5 hours. And that was what parents were happy with. And of course, that would fluctuate up if they improved, and obviously could potentially fluctuate down if they regressed or needed some respite.
Yeah, I think that is a really important point, actually, Chris, that if the person who asked this question is in a situation where the LA is saying the child can't manage more than 12 hours a week because of their needs, that is a question that really is only going to be resolved by evidence, and it all becomes a lot more complicated.
Yeah, absolutely. But there should be I don't think general rules such as it's only going to be 12, it's only going to be core is the problem.
I mean, I suppose we have to be practical too. I mean, how practical is it to have music, for example, lesson delivered at home? You don't have the room for the piano.
Yeah, well, yeah. I mean, they are doing science. It's difficult to say. It's so fact specific as well. What is quite good is there are now, and we've seen it since COVID, a huge explosion in the number of online schools, like actual schools. I know of a couple in particular where some of my clients who have quite severe school anxiety and need education otherwise have access to full-time, multiple subject curriculum, online. And it's actually a business that's doing that. So again, there are more facilities to do, as you say, subjects that perhaps wouldn't lend themselves to online tuition in an online environment. But it is all about the circumstance of the case, what the policy says expressly, and what the facts are.
Absolutely. Next question then. What happens when you attempt to fight for specialist provision that isn't there?
Good question.
It is a good question.
Good question. I think the difficulty is, so firstly, what do we mean by specialist provision not being there? And I think that's a multifaceted question. Do we mean that it doesn't exist at all? Are you going for the unicorn provisions word, like no one nowhere ever does this? And I think that's highly unlikely. Most parents are asking for things that they've researched or heard about. Tribunals have an expert knowledge of the types of systems and provisions that are available, in England or in Wales, wherever they're sitting for our purposes. So it's highly unlikely you're going to get to a stage where the provision listed in a plan is completely impossible to deliver. However, whether something is available in your local area is a very, very different question. And we have seen, for example, there's rural authorities in Wales where, because they're very sparsely populated across a large geographical area, won't have the same level of provision or availability of provision that London will, because it's very densely populated in maybe a smaller geographical area. So there are often cases where you don't have a particular specialist provision in your local area that your child needs. And at that stage, it's important to recognise the local authority does have an obligation to cast that net wider, or to possibly engage services from the third or independent sectors to provide that provision. So sometimes that means the child has to be educated in another county. Sometimes, because of the distance from their home, that may mean that the provision has to be residential, and we've come across that a lot. Again, sometimes it means that they have to consult with, as we say, independent providers to bring that support into a local provision at the cost of the local authority. So it's always fact specific about whether provision is impossible to deliver or simply difficult to deliver. But as we talked about earlier, Section 42 of the Children and Families Act, which makes local authorities responsible for the delivery of provision, and there's obviously equivalent provisions in Wales, where they are on the hook for it. They must provide it. It is not, we've tried our best and it's tough. It is, no, you must secure it. That is your obligation. Whether it's costly, whether it's challenging is not really relevant. You know, they have an obligation to provide it.
I mean, Charlotte, the questioner in this case is saying, well, because of provision that they are fighting for is not said to be available. I'm assuming that that's what the questioner is saying, not available, I presume, in the area, in their area.
Yeah.
Their child has had to struggle in a mainstream school that's not unsuitable. I mean, that's the practical. We have this practical question, don't we, quite often?
We do.
Don't we?
We do.
And I suppose what Chris is saying is that the local authority should not look just purely what's in its own area, but beyond, and even in the independent sector.
Yeah.
And broadly, we've answered that question then, I think.
Yeah, I think that's right. Yeah.
So moving on to our next question, and I'll take the chair of host on this occasion, Mike. University support. So, where a young person had therapies that were provided by their education healthcare plan in section F and the health section and were funded by the local authority, they are essential to be able to access education, but DSA do not class them as educational, and the CCG will not fund. Young person had one-to-one support, but uni won't provide it and is now at crisis point and may drop out. Lack of information, advice, and support available for SEN children who make it to higher education. What help is available? Mike, I'll throw this one to you.
There's quite a lot of points in that, Chris.
Yes.
Disabled students' allowance is available to students who require additional support when they're at university. But disabled students' allowance has limited means. You can have, for example, a note taker. You can have specialist equipment. You can have a mentor. You can have a study skills advisor. All of those things are classic things that disabled students' allowance is supposed to cover, and they're important. And then also on top of that, if you're preparing yourself for university, a good thing to do at the annual review stage before you get to university is to invite social services in to ask them about other things that that young person might require. For example, in dealing with everyday things such as cleaning the home, organising themselves, going to university, and dealing with friendship issues and so on. But this question, I think, is more focused on individual one-to-one, and that raises a very interesting point because a university will ordinarily provide a note taker in a university because someone may have problems with writing their notes down as quickly as they may need, and they will have a mentor. They should provide a mentor, so someone to whom you can go when you're having a crisis and you're emotionally struggling. And a study skills advisor is to help you organise your work, organise your coursework, deal with coursework deadlines, etc. So all of those things should be part of the package that you see ordinarily within a disabled student's assessment. The question here, though, is should the therapies also be delivered by a university? And that's going to be really tricky because generally, I think a university would say we're only here to provide that which is reasonable as a reasonable adjustment. But the interesting question would be is whether or not, without that therapy, can that young person access the course? And I think that's a grey area. And I think, because we often seen in contracts, because what's like a university relationship with a student is a hybrid one. It's governed by private law and it's also governed partly by public law principles. And so what you have in that instance is an obligation on the university's part to apply good, reasonable thinking to the case. And I think if the conclusion is that it's going to be very expensive to provide it, you might say, well, the university can't and shouldn't have to deliver it. But I think then that's going to be subject potentially to a challenge under the Equality Act about whether or not you are offering a service that's accessible to all of the students. So I think that it's a grey area. I think it's very possible that a court might say, in the right case, on the right facts, that without this therapy, you have taken in this student, you've accepted the student's needs, and you've accepted all the disabilities that they have, and you've offered a place. It's your responsibility to provide it under your reasonable adjustment duty. Charlotte, do you agree with that?
Yeah, I think broadly I do. It is always tricky with reasonable adjustments because it's not an absolute duty in the way that it is under the Children and Families Act. and every case is going to be horribly fact specific. And I think the main thing is that budgetary concerns are an issue, whereas under the duties that local authorities have to children under the Children and Families Act, that they're not. But yeah, I mean, I think I agree with your analysis, and we all know that you are very experienced in terms of disputes over reasonable adjustments with universities.
Well, yeah, I mean, I think that it's the old saying, isn't it? You hear in law that when you can provide 1 pence to someone to clean your house. It doesn't matter it doesn't matter how much you're paying. The question is, you are giving consideration. Yeah. And you're giving £9,000 in tuition fees, and for that you're supposed to be providing a service, and that service is a service that should be accessible to all those, including those with disabilities. So I think that, I'd like to know more about from the questioner about the individual facts here. But the young person here is at crisis point, and what I would say practically, the best practical advice I'd give you is to call the university straight away, ask for a meeting, and to discuss with the head of the student support services and get them to discuss the learning plan that they have created. And I would probably suggest that you get some advice too, get some legal advice, and look at your evidence.
I think that's a really good point. So to quickly summarise, I think there was excellent points there. So unlike the obligations to children under the Children and Families Act we talked about, it is not an absolute duty. There are limits to the obligations on universities to provide support and under the government through DSA. So they can take into account practical considerations as costs and available resources in deciding whether or not an adjustment is reasonable under their duty to make reasonable adjustments. But those duties still exist, and it is the onus on the university to demonstrate that any particular request or level of support is unreasonable. So make sure you have those meetings and those discussions, and do take advice, because there is a risk of discrimination. A failure to make reasonable adjustments under any of the 3 requirements is a form of disability discrimination as confirmed by Section 21 of the Equalities Act. So it is very important that you have that instruction, have that advice, and then go forward and communicate with the university.
Yeah. Chris, well, I'll take question number 12, and I'm going to put this question to Charlotte. What are a child's rights if they have been permanently excluded from a private school? And the local authority have told the questioner that there's nothing that they can do as there's no right of appeal.
It's difficult to be completely comprehensive without knowing all of the circumstances. But I think, firstly, the local authority probably means that the parents cannot appeal the exclusion through the statutory process that applies to maintained schools and academies. So what the parents can't do is go to an independent review panel in the way that they would be able to if their child had been at a local authority maintained school. Private schools have a very different relationship with their parents and children than state schools do. It's a relationship that is regulated by principles of commercial contract. So when you send your child to a private school, you sign a contract with the school that is, to all intents and purposes, a commercial contract for the provision of services. The contract is between you and the school, although the school has pastoral duties to your child. And so your remedies, as we like to say as lawyers, your path of redress is largely through that contract, unless there is some sort of discrimination at play. So if there is some sort of discrimination at play, if it's about disability discrimination, and I think we can assume, given that it's the question that's come to us running this education magazine, it probably is a disability discrimination issue, but it would apply to any discrimination that is operative in schools. If there is a disability discrimination issue, then you can bring a claim within the first tier tribunal. And you can bring that claim against an independent school in the way that you could bring it against a state school. And if you were to succeed in that claim, the first tier tribunal could, if it thought that it was appropriate and if that's what you were asking for, could order reinstatement. So that's the significant remedy if it's discriminatory. Now, if the decision to exclude is not discriminatory, independent schools are required to have complaints procedures which can be used as routes of appeal. So if absent any discrimination, you can appeal the decision to exclude via the internal complaints procedure. If the outcome of that procedure is that the head teacher's decision is upheld, and I think it's fair to say that that is usually the outcome. I wouldn't say don't go through the complaints procedure, but I think be prepared, as with any appeals procedure, for the fact that the original decision is reasonably likely to be upheld. then you could bring a claim in contract in the county court, but that has potential cost consequences. It's a complicated and formal process, and it can be very, very difficult. It's very difficult to persuade the county court to do their equivalent of reinstatement, which would be a claim for specific performance. It would be very difficult to do that. And in terms of financial remedies, how do you value the loss to your child? It's just very difficult. It's very difficult to do. So unfortunately, this is an area, if you send your child to an independent school and your child is excluded, I think it's fair to say, isn't it, chaps, that unfortunately your avenues of redress are limited in a way that they wouldn't be if your child was at a maintained school.
Yeah, I think that's right.
That is right. It can be very tricky. Now, that does not mean, to be clear, and not that we are saying, not that Charlotte is saying, that they have carte blanche. They do have to have justification for exclusion. They have to follow their own procedures, which will be part of their contract with you to go through exclusion. And it is very, very, very fact specific as well. There has been case law about when an exclusion has arisen from a disability. And of course, if it does, then the Equality Act requires that it's a proportionate means to achieve a legitimate aim. You can't just exclude. You have to look at, well, is exclusion proportionate? Are there lesser, more proportionate sanctions that can be applied? So there are certainly things to consider. Yeah. One thing I would absolutely say, although I don't think any parent who's faced it or whose child has been permanently excluded is resting on their laurels. Often these complaints procedures and appeals procedures internally have very short time limits, so make sure you know them and are accessing them. And secondly, it's important with discrimination to know that the usual time frame that's applicable is 6 months. So again, don't hang around. If you think something may have gone wrong, get some advice and find out whether or not you may have a claim.
Again, I think that the best practical advice is to use the complaint scheme first,
yes,
isn't it, really? And within that complaint scheme, if it's a discrimination point, raise it, because it often triggers some concern on school,
absolutely,
particularly the private school sector.
Yeah, absolutely. And we have seen cases where, that process has yielded positive results. So it's important to bear in mind that just because a system is within a kind of contractual kind of framework, as it were, that it's going to be less effective than an independent system. It may be, but that remains to be seen. So don't be shy of putting in a complaint or an appeal.
Well, on the point about discrimination, it brings us to the next question, really. I mean, following the C&C case, the famous case which was back in 2018, where Judge Rowley said that it's not a choice for autistic people to be unruly, if you know what I mean.
Yes,
it's not a choice. The questioner in this case says, why does it appear that so few Equality Act claims are not brought together at the same time with the special needs cases? And they say, well, shouldn't you use the weapons together in order to achieve an effective outcome within the special needs tribunal process? Charlotte, what do you think of that?
Well, it's an interesting question. I mean, firstly, you don't always get a discrimination claim and an issue in relation to an EHC plan that arise at the same time. So many of the disability discrimination claims that I've been involved in against schools are cases where the child has been refused an EHC plan or nobody has asked for an EHC plan for some reason. And so it's just not really in scope. So although at the point where I'm looking at the disability discrimination claim, one question you might well ask, and I think we'll come to this later, is, has the school approached the local authority to say, we think this child needs support that we can't provide, and if not, why haven't they? The fact is that the EHC needs assessment process takes months, whereas disability discrimination claims come on for hearing quite quickly. So you wouldn't normally want to delay your disability discrimination claim for an indefinite number of months to see if you got an EHC plan at the end of it. And there wouldn't really be much advantage to doing that in most cases. I mean, there might be, it depends on the case, but broadly, there probably won't be. You'll probably want to get your disability discrimination claim done quickly. I have done some cases where there is both a special educational needs hearing in the sense of a challenge to an EHC plan that's been issued and a disability discrimination claim in scope. And where that happens, what SENDIST will sometimes do is list the disability discrimination claim on one day, the claim in relation to the EHC plan or the appeal in relation to the EHC plan on the second day, and they will be heard on consecutive days. They will be separate hearings for various technical reasons. You can't join them together, but they will be heard by the same judge and the same panel because there are issues that are common to both. So the answer to that question is it can happen. it really isn't always necessary. And quite often you just don't have the claims running at the same time in a way that allows you to do it.
I think the question, though, is thinking is more the tactical benefit of it. I mean, in terms, would it be tactically beneficial to argue that, for example, I suppose, unmet special educational needs requires more specificity in the plan?
Yeah.
Oh, it can be. I mean, I think if you're arguing about setting, and the local authority is saying this school is appropriate, and you've got a good claim against the school for discrimination against your child. I mean, let's say you've got a child who's got I'm not sure we're staying high functioning ASD, but what used to be called high functioning ASD, a child who's cognitively able but has ASD, which causes them challenges, and the school is just failing to make adjustments for them, or it's obviously not the right setting for the child. And part of that is around the fact that it can't adjust for the child, then it might well be tactically beneficial if your challenge to the EHC plan has come at the same time as your disability discrimination claim. It might be tactically beneficial to have both of those claims heard together so that the tribunal can take an informed view as to whether or not, in fact, there has been discrimination at school. Because in an appeal against the EHC plan, the tribunal often will not get drawn into questions about what's happened in the past. The tribunal will say quite often, we are forward-looking, we're looking at what this child needs now and where those needs can be met. And that can make it very difficult to air past issues of discrimination, even if you feel that they really are relevant to the question of whether that setting is right. So it can be tactically beneficial, but it's not always possible.
Yeah, it's very fact specific, as Charlotte said. It's very important to recognise they are serving completely different functions. Yeah, as Charlotte said, the EHCP appeal is looking today and forward from today. What are the child's needs right now? And what are they going to need moving forward? The discrimination case is by nature looking backward. Okay, there's been an issue which you consider to be discriminatory. Let's investigate and determine whether or not we think that's the case. They don't really overlap in that sense. I think the only time, as Charlotte mentioned, they can be tactical is if you're going to be staying at a school and you want to kind of change their perspective on things. But I think the concern I would have is that legal processes are very effective at affecting change on a more functional level, maybe changing systems that were discriminatory, maybe changing practices or perspectives that were discriminatory, but it doesn't really change hearts and minds. It is kind of forcing schools. So if you have a school that you feel its entire approach to discrimination is wrong, then you absolutely, its approach to disability is wrong and discriminatory, you absolutely should take that up to tribunal. But of course, you then may want to move on anyway in the EHCP process. It might already give you an indication that school is not right for your child. So you'd approach the two things differently. One thing I would say as well as a pragmatic consideration is costs. Where parents aren't eligible for legal aid, if running two cases, and they are different cases, often on related but different facts and related but different evidence, you might want to fight the one that's most effective. And usually EHCP appeals are the most effective for resolving matters moving forward.
Thinking about the time, we haven't got a lot more time left, actually, and we've still got a lot of questions to go through. So I suppose I'll skip on to the next one quickly. If my son has autism, selective mutism, and sensory difficulties, should his sensory diet and salt be in section B and F?
Absolutely. Yes, they should. Very, very clearly. It's without question that they should be in sections B and F. SALT has long been established as special educational provision. The Children and Families Act is very clear that anything that educates or trains is special educational provision. So absolutely yes.
Absolutely
yes.
I'm going to be very slightly pedantic and say, as provision, it should be in section F. The needs that give rise to that provision should be in section
Quite right.
B, yes.
Yeah. The selective mutism, ASD, and sensory difficulties in B, provision in F. Yeah, quite right.
Can the local authority cease an EACP because you finished education at 19 and are undecided on what to do next?
Yes, they can. If you have finished education, and this is a big caveat of what do you mean by undecided? So if you've left education, strictly speaking, yes, they can cease because you're no longer in education, and that is part of the requirements for an education healthcare plan. However, that does not mean to say that as soon as you express some uncertainty as to where you're going, they should instigate the process of cessation. That's why transition reviews should happen early, because it will give you a couple of years to kind of make those steps. But if, let's say, a child or young person in these circumstances, of course, being 19, wants to take a gap year or some kind of equivalent to maybe try the world of work, or maybe just, do some traveling, whatever they're able to do or want to do, it's reasonable for the local authority to cease in those circumstances, but that will not prevent that individual, provided they're younger than 25, going back through the reassessment process. I appreciate that can be frustrating, but it is a requirement of an Eacp that they are in education.
Thank you, Charlotte. If a local authority is ordered by a tribunal to carry out an Eacp assessment and fails to do so within the statutory time limits, partly blaming the waiting list for SALT and OT, what recourse is there is the question. And I think I combine it with another question that's been taken later is, what if they also then fail to comply with the plan? So we know the weaponry here, don't we?
Yeah, the answer in both cases is a claim for judicial review, which you start by writing to the local authority to invoke what is called the judicial review pre-action protocol. So you have to start by writing to the local authority and saying you are in breach of the statutory deadlines for completing your needs assessment, or you are in breach of your absolute duty under Section 42 of the Children and Families Act to secure the provision that's set out in the plan. I'm giving you notice that unless you remedy this immediately, I'm going to bring a claim against you in the High Court for judicial review, which, as we know, is a legal mechanism for having the High Court scrutinise acts of a public body such as the local authority that appear to be unlawful.
Very important caveat as well to just make everyone know that judicial review is an extremely powerful tool, but it does come with cost consequences. So even if you were to bring it yourself and you were to lose, you may have to pay your opponent's fees. So it's extremely important, if you consider judicial review, get legal advice.
Oh, yeah.
Get legal advice.
Specialist legal advice.
Yeah, absolutely crucial, because you do not want to try it yourself and get a 50 grand bill at the end from your opponent because you didn't do something technically right.
When a child doesn't have an Eacp and is masking in the setting, the questioner asks, if an accommodation is requested, for example, to start 20 minutes later at school, can a school refuse this?
So, potentially. So firstly, there are, as we've talked about before, duties to make reasonable endeavours to meet SEN under Section 66 of the Children and Families Act, and there are also duties to make reasonable adjustments under Section 85 of the Equality Act. So the school does have obligations. However, those obligations arise if the child has SEN or has a disability as defined by the Equality Act. So unless your child has those needs as defined, then the school may refuse, because it does not have the obligations to meet those needs generally to children who don't have SEN or don't have disabilities. But let's take into account that your child does have those. As long as you can demonstrate that their need to start 20 minutes later comes from their disability, be that school anxiety, be that some other reason that they need that, I would say that sounds fairly reasonable. We have talked about the limits to reasonable adjustments, about having considerations of financial and resources, which are very different to those applicable to local authorities. But a 20-minute later start shouldn't be difficult to implement.
But Charlotte, wouldn't you have to satisfy the local authority? Because otherwise, would you not be committing an offence by failing to secure your child's regular attendance at school if you were attending late all the time? Lateness is another crystallisation, if you like, of the power that they would have to. So local authority should take the battle with, shouldn't it?
I think it's both. I don't know what your thoughts are, Charlotte.
No, I would agree. But yes, I mean, your initial battle is going to be to make the local authority understand through provision of evidence that this is an inability to attend and not sort of truancy or messing about.
And with the school as well, if they do refuse unreasonably, you may have a claim in discrimination.
Okay, we have to move on. Is it true that if you ask for a personal budget in the Eacp, this comes out of the money the school gets given for your child? That's the next question. Charlotte.
I mean, my answer to all of these questions about how things are funded broadly is this is not really a parental issue, because the only question for the parent is, are they getting the money that they need? Is the child getting the provision that they need, and is that being properly funded? And if it's not, as a parental representative, I would always say, you're the agencies, you sort it out between you, LA, school, social care, whoever. We don't really care who's funding this, but you've got to sort it out because there is a legal obligation overall on you to fund it. I mean, I guess the answer is it sort of depends, doesn't it? I mean, you might have a situation where there is funding in place for speech and language therapy, for example, and you as a parent might go to the local authority and say, look, I actually want to use a specific speech and language therapist. Can you give me a direct payment on what you would have paid for the SLT? And then I'll use my own and I will top up if necessary. The LA doesn't have to agree to that. But if they do agree to that, they might do it as a direct payment. And I guess, yes, it would come out of the pot of money that otherwise would be available between the LA and the school.
Yeah, and under the statutes, that's what a personal budget is. It's a way to allow parents to arrange the provision that would otherwise be arranged by the local authority. So you won't get double payment. So the school won't get money for the speech and language therapist, and you'll get money as well. It's one.
And
one level.
I guess, Chris, local authorities might like it because they say, well, actually, over to you then, parent, because we can't, right?
Yeah, it's important as well to be clear that local authorities are under an obligation to make sure the money they give you is sufficient to arrange the provision. So as Charlotte said, that doesn't mean you get to choose exactly who does it, but if there's only one person available, that's fine. You know, it still has to be met.
I have to ask this question because it tickled me. The question is, can a local authority refuse to put a child's diagnosis in an Eacp? Can they put incorrect information in?
Yeah, it's one of those that it's laughable in the sense of clearly not, but the real shame is this question's been prompted because that's happened, and we see it all too often. So the answer is absolutely not. There is a requirement that the plan be accurate. Now, that does not mean that local authorities and parents or young people necessarily agree about what is accurate, and that's where the tribunal comes in. However, they should not put wrong information. So that can be as simple as wrong names. Obviously, that can't be in. It can be as complex as, the wrong diagnosis. Clearly, that shouldn't be in unless there's evidence to show that actually the child does have it.
I'm finding, I'm not sure whether you see it too, Charlotte, that the local authorities tend to not take or give the parental voice the prominence that it really deserves. And the statute requires of the local authority. And it's one of the questions that we skipped, if you like, as dealt with by previous seminars. But a parent does have a very important voice, as does, of course, the child or the young person.
Yeah. Well, Section A will contain parental views and aspirations.
One thing that I have seen is that sometimes a local authority will put less weight on the opinion of privately instructed experts than it will on the NHS experts that it uses under its commission services. But I mean, I think, and that can happen sometimes, and that is very frustrating when it does happen, because in the absence of clear evidence that somebody is not doing their job properly, the independent expert's voice is just as valid as any other expert's voice. They're qualified in the same way. They have the same expertise. I mean, one thing that can be, I do remember a case that I did where we had a multidisciplinary, I was for parents, we had a multidisciplinary assessment that diagnosed a child with a girl in her teens with autism. And of course, very sadly, there are still particular difficulties with getting diagnoses for girls who are cognitively able and who also have autism, because despite the NICE guidelines clearly saying, be careful, this young person may not present as autistic, will not have the social difficulties outwardly that you might sort of stereotypically see with autism, et cetera. We had a report that diagnosed her with autism. The local authority turned up with what they said was a multidisciplinary report, which was one paediatrician who said he had spoken to other experts and they didn't agree with that diagnosis. And so this question reminds me of that, because that is a battle of evidence. You have to go to tribunal, you have to have your expert there. The local authority should have their expert there, it's up to them. And the tribunal has to decide between those two diagnoses. And in that situation, obviously, there is a risk of a finding that your diagnosis is wrong and the LA's is right, but there's also a risk the other way around.
Yeah, thanks, Charlotte. I mean, it's good advice. I mean, very quickly, we have to do this one. Literally, we only got about 2 minutes left. But when specifying SALT provision, speech and language provision, that is, which is educational, is the NHS permitted to base it on what is reasonably required, or should it be at the level that meets all of the educational needs? Quickly.
Well, it goes very much to what Charlotte just said there about the battle of evidence. So to be clear, what's in Section F should be what is necessary. That is the threshold there. So it isn't beyond what is necessary, it is what is necessary. And what you may find is that the NHS and parents or parents experts actually disagree on what is necessary. So that is where the battle of evidence comes in.
And I guess, Charlotte, the distinction is what the NHS consider it will, in accordance with its criteria, provide, and that which the local authority within its criteria.
You can get easily confused. You can get easily confused between these are our pathways and our criteria for local treatment according to policy, and this is what this child needs. I mean, the only thing I would say is to parents, don't get too bogged down about the difference between reasonably required and necessary and all needs or some needs. What can your child reasonably be expected to achieve given the needs that they have? What do they need in order to achieve that?
Absolutely, good advice.
And it's a clinical decision as well. As we say, we're lawyers, we're specialists, we work in this field, but it's not for us to decide what a child needs or does not need in terms of provision. You require qualified experts to do that. So here, get a speech and language therapist assessment. They'll tell you what's necessary.
Local authority says EOTAS, education otherwise than at school, for those who don't know what that is the only option, as all schools consulted have said no. Can they do this? The question also says, can they allow a young person aged 19 with an Eacp to do functional skills only rather than GCSEs, even if the child is capable of doing more than just pure functional skills? The tutor apparently has told this questioner.
Yeah,
that's exactly what they.
So it's a bit of a twofer for our last question. So I think we'll do the second one first. So the answer is no, they can't force them to do functional skills only. The plan should meet the child's educational needs and outcomes. If their outcomes can be better, then so be it. As to EOTAS, can they propose EOTAS in a plan? Yes, they can. That is a reasonable way to meet a child's needs. However, in the circumstance of any particular case, should that be what they do, will remain to be seen. If there are schools that are available, then obviously they should be favoured where possible. And of course, a parental preference can be expressed for schools, and often they must be named and can sometimes be ordered to be named. So it will depend on the facts of the case, but they can offer EOTAS, but that does not mean as a parent you need to accept it. Again, you do have a right to appeal to tribunal.
Thank you, Chris. Charlotte, any final thoughts on that?
Yeah, just, what does all schools consulted mean here? Because the LA will have consulted the schools that it is interested in, if you like. And it will also consult with schools that parents put forward. But parents can put forward any number of schools anywhere in the country. If the school that meets your child's needs is so far away that your child has to attend residentially and you and your child are comfortable with that, then there is no reason why you can't put that before the LA and duke that out at tribunal if you need to.
Why not build some new ones?
Well, I hear they're going to.
Right, okay. Well, thank you, everyone. I mean, there was one point that was last raised. I didn't cover it in the question, but one of the points was made was that can a foster parent bring an appeal? And I think we debated it before we came on this program recording. That the general feeling is that a person who has care of the child can bring the claim themselves, and not necessarily just the natural parent. The child lives with the foster carer. That is the person who cares. It's section 567, I think it is. Charlotte, is that right?
I think so, of the Education Act. I mean, we have to be slightly careful about it because the Code of Practice for the Children and Families Act seems to suggest that foster carers are not to be treated as parents, but it's really unclear and yet to be tested.
Yeah, Children and Families Act actually doesn't define parent. The Education Act previously does and does take care of the child. So it's unfortunately one that needs to be tested. But at the same time, if you're in a position to advocate for a child, always try to advocate for the needs and always look to take.
I got a crystal ball here. See this crystal ball? I'm going to tell you what the answer is. I think a foster parent can.
Well, there we go. There we go. Hopefully that prediction comes true. Well,
thanks to all of our guests. Thanks, Charlotte. Thanks for joining us today, and thanks, Chris. Been very amusing. I think it's been an achievement to get through all those questions.
I think so. It's been a busy one.
But thank you all for watching, and look forward to seeing you again in the Education Magazine in the not too distant future. Thank you.